All right, I think we're you're ready to proceed. Welcome to an oral argument session of the 5th District Court of Appeal. This actually was one of the first cases that got caught up in the pandemic and was originally scheduled in April, and we were unable to get it accomplished then, but through the use of technology, we're going to do the best we can to have it rescheduled as quickly as we could, which was today's date. I'm Judge Cohen. The other members of the panel from Orange County, Judge Wallace, also from Orange County, and Judge Edwards, who is from Seminole County. We have a number of cases on our docket this morning, and as a result, we have to stay fairly focused on our time, but I'm going to give some flexibility to the extent that I can, because this is a fairly involved case and has a lot of moving parts to it. This case is Chaudhry versus Advent Health System, case number 18-2380. We have an appeal and we have a cross appeal. And so the procedure that I'm suggesting, although I can tell you that I'm open to do it any way that the lawyers would like, is to allow the appellant to proceed and to reserve as much time as they would like to both respond to the argument made by the appellee on the initial issue, and then address the issues on the cross appeal. The appellee will also have an opportunity to reserve as much time as they would like to first go forward on the issues in the initial appeal and then address the issues on the cross appeal, and then we'll be allowed to have rebuttal on the issues of the cross appeal, unless you all would like to do it any other way. And I say that, with sincerity, because quite frankly, I think that there are some issues in the cross appeal that would have significant impact on some of the issues involved, and that in fact could moot some of the issues on the initial appeal. But that said, any preference, either Ms. Downs or Mr. Connolly, on how you wish to proceed? Ms. Downs?
I think what you outlined was great. If you would give us an opportunity for rebuttal on the cross appeal component, I'm happy to argue both the response to Mr. Connolly's argument and our appeal in my portion with a rebuttal for our appeal. If I said that right.
Yes, Your Honor. I would prefer to address our main appeal, and then I was going to reserve time for rebuttal on that and to address Ms. Downs' argument on their cross appeal. If I understood Your Honor to propose that I would pre-address their cross appeal, I would prefer not to do that.
All right, that's fine. No problem.
And it looks like I may have something flashing somewhere behind me. I don't know what it is, though. Is that distracting it all to the court?
No.
No,
No, we're fine. Any Judge Wallace, Judge Edwards, any issues?
No, I don't see it right now, but I noticed it before, but I don't see it flashing here, so I don't know what it is.
All right. Maybe it's some extraterrestrial. All right.
Wouldn't surprise me in 2020.
Yeah, that's right. Okay. 18-2380, Chaudhry versus Adventist Health. Mr. Connolly, you may proceed.
Thank you, Your Honor. May it please the court, my name is Lincoln Connolly, and I represent Dr. Ahmad Chaudhry in this case. I would request to reserve 10 minutes or such greater or lesser time is remaining at the end of my argument here on the main appeal for reply to Florida Hospital's argument on the main appeal and any cross appeal argument. This appeal presents from a jury verdict in Dr. Chaudhry's favor in a Florida whistleblower action in which he claimed, and the jury found, that his employer, Florida Hospital, unlawfully retaliated against him for his objections to and refusal to participate in Florida Hospital's violations of several Florida patient safety laws, resulting in harm and death to patients. The jury awarded him $2.85 million in damages. The trial court erroneously vacated a portion of that award for this loss of future earning capacity, which was $1.5 million. And it held the evidence was insufficient to support it. That ruling was error. This court reviews that ruling de novo, and the court should respectfully reverse and remand for an amended judgment to be entered on the full jury verdict.
Now, the expert testimony on loss of future earnings had Dr. Chaudhry in the position of the head of a unit for transplants, correct?
Under one of the surveys, that was the category of information that was provided in one of the surveys, yes.
And why isn't that completely speculative?
Well, because first of all, we're talking about future earning capacity and looking at what he can earn over his, in this case, 20.5-year life expectancy. So it's appropriate to look at the salary that a person may obtain over that 20.5 years of time. But number two, it was consistent with the other survey data which he looked at, which is cardiovascular surgeons, which included in that study heart and lung transplant surgeons as cardiovascular surgeons.
Mr. Conley, was there ever any evidence that Mr. Chaudhry, prior to this lawsuit, had ever held a position equivalent to the chair or head of the transplant department in any medical facility?
No, Judge Wallace, because this was his first job after his 2-year fellowship. So he was.
And was there any testimony as far as what is the likelihood or percentages of doctors that practice in his area of medicine that actually attain the position of chair or head resident in a transplant department of any facility the size of or equivalent to Florida Hospital?
I believe the closest testimony there was is that normally these programs consist of a lead surgeon and then a second surgeon, and then the second surgeon generally will ascend to that lead surgeon position after the lead surgeon retires or moves on. And I can get that site for the court. It's in our briefs.
But there was no testimony as far as the likelihood, the likelihood of attaining that position. Is that correct?
No, there wasn't testimony on that specifically, but Dr. Chaudhry here was an eminently qualified young surgeon. He had not only a 2-year fellowship at one of the leading transplant programs at UCLA for heart and lung transplants, and he also had the training in ventricular assist device placement. So he's kind of triple specialized in this area through UCLA, and he also had VAD placement training before that at the University of Illinois, Chicago.
Mr. Conley, would my loss of earnings be that of a United States Supreme Court justice?
Not necessarily, Your Honor, but we can take into account what they are paid in determining what judges make in the field and in terms of what you may attain someday, because we don't cabin or cubbyhole plaintiffs with the job that they have at the time that they are injured if they have a future claim.
Well, but it can't be speculative.
I agree, Your Honor.
And it just seems to me that there's a great deal of speculation in that, and there certainly would be a great deal of speculation in my ascendancy to the United States Supreme Court.
I hope not, Your Honor, but
I can guarantee it.
If I can curry favor with the court. I'd ask Your Honor to look at it this way. This was the testimony. It wasn't only Dr. Krause's examination of the survey data. It was also, this is Dr. Chaudhry's first job. So he's underpaid from that, Dr. Krause testified. He started out low. Florida Hospital was a new program. It wasn't yet CMS, Center for Medicaid Services, and UNOS certified. And so profits and wages are lower with that. Once it becomes certified in both, which it did, CMS before Dr. Chaudhry was fired, UNOS after he was fired, then its profits go up and wages go up. Dr. Chaudhry had this triple specialization, so he's relatively unique in his field. And by the time of trial, he would have been in his 6th year, so his earnings would have been increasing. He was hired at $300,000. He would be entitled to $400,000 under the contract once he was board certified, which he became board certified after he was fired. He would be entitled to a $50,000 bonus once they received CMS certification. They were, and he could renegotiate just under that Florida hospital contract for 5% annual increases every year. And so,
Now, Ms. Conley, I know that you initially indicated that you didn't want to talk about it, and so I'm not going to interject too much of it into it. But just to give some context, if we felt that the jury instruction was wrong, and that necessitates a new trial, does this issue become moot?
if they're entitled to a new trial on liability under the jury instruction or causation, can I get back to Your Honor on that?
Sure.
After Ms. Downs argues, I'd like to think through that.
Sure. Okay.
So turning back to the question about speculation and such, it is clear that he was terminated under the jury verdict because of protected activity. It is clear that he wasn't able to return to a job as a heart and lung transplant surgeon through the time of trial because of that unlawful termination.
What testimony was there that because of his unlawful termination, he was not able to get a job?
Dr. Krause testified about that.
That's not, he doesn't have any facts to testify. He has an opinion. What factual basis is there for the statement that he could not obtain a transplant surgeon position because he was terminated from Florida Hospital?
Well, both he and Dr. Chaudhry testified about that. Of course, a fact where he applied and somebody said, no, you were terminated, we're not going to hire you. That doesn't exist. But Leanne Burgess.
In fact, what did exist is the headhunter, if you will, said because he wasn't board certified, all the positions that particular headhunter had required board certification, correct?
He didn't testify, but I believe there was an email that was introduced that said that. However, that was not undisputed. Certainly, Florida Hospital hired Dr. Chaudhry without board certification, so it is possible to get those jobs in the field. There was no testimony that Florida Hospital is the only hospital that does that. And Dr. Krause testified about Leanne Burgess's testimony, which was admissible, that she said that Dr. Chaudhry would find difficulty working in transplant, and she was the transplant administrator at Florida Hospital. And so we submit that the evidence, in a light most favorable to Dr. Chaudhry, as is required, requires the court to credit that aspect of the evidence in the jury's verdict. So you have a man who's not going to be able to work in transplant surgery again. There's testimony that heart and lung transplant surgeons absolutely earn more than general cardiovascular surgeons, which is the job that he finally was able to take just a couple months before trial when he found. So you have a loss of earning capacity right there. And the question is how to value it. There aren't a lot of heart and lung transplant surgeons. They don't go posting their salaries all over the place. It's not easy to find out what it is. Both experts did their best, in part consulting surveys, but Dr. Krause also looked at what others earn in the field and found some earn between $1 million to $2 million. Now, admittedly, that was chairman of a department at UCLA. Those were directors, but these are things to show what his salary can grow into, which was $300,000 when he was fired. And Dr. Krause conservatively estimated it to be $750,000. It was reduced by the $500,000 set-off that he was making at Kentucky One. And the jury awarded only $1.5 million, which over the 20.5-year life expectancy is only like $73,000 per year. There clearly was a loss of earning capacity. The jury judged the evidence, listened to everybody's arguments on it, and came in at $73,000 per year for somebody who will never again work as a transplant surgeon.
Right. Mr. Connolly, if you wanted to reserve 10 minutes, you're there now.
I see that, Your Honor. Thank you. I'll just make one other point on this. If for some reason the court does not reverse on this issue, we have point 2 in our appeal that deals with discovery of Dr. Wittner's contract in order to further prove up loss of earning capacity. The court found that the evidence wasn't sufficient to prove it. If the court is going that way, based upon the evidence, what Florida Hospital admitted was a reasonable salary for a heart and lung transplant surgeon is at least calculated to lead to the discovery of admissible evidence. and we should be allowed to obtain it. So the court should reverse order that produced and give us a new trial on loss of earning capacity where we can introduce that evidence. Thank you, Your Honors.
All right, thank you, Mr. Connolly. Ms. Downs?
Yes, and Your Honor, as I understand the discussion we had earlier in your instructions, I'm to respond to Mr. Connolly's issue about the lost earning capacity. So I will do that first and then turn to our assignation of error under our brief. As this court well knows, obviously well prepared, the judge took away the future earning component of the verdict, finding that there had been a failure of evidence to show a lack of capacity. And it's interesting to hear this argument because when you read the cases, you can see how people tend to gloss over the capacity component of this requirement. And it is exactly linked, as both Judge Cohen and Judge Edwards noted. And the problem is Florida's very strict law on speculation of damages. We see it in the lost profits component, and we see it here. So what happened?
Ms. Downs, let me ask the same question of you that I asked of Mr. Connolly. If we agree on your cross appeal that the jury instruction was incorrect, is this issue moot, or do they get a second crack at it on retrial?
Well, of course, Your Honor, our request is that this case be reversed and remanded with instructions to enter judgment.
Assuming that we don't do that.
Then assuming if there is a new trial, Your Honor, his position is that he just gets a new shot at damages, and they are two interlinked, Your Honor. If there is to be a new trial, I don't believe he should get another shot at proving something he was unable to prove. And I think I said something circular there, which I didn't intend. But the problem here is there's not only no reduction in capacity proved as a matter of law. Actually, the evidence proved, and Judge O'Kane noted this, that Dr. Chaudhry, by the time of trial, was making $100,000 more than he made under the contract he's traveling under. And that doesn't mean, as this court well knows, and there are 5 DCA cases that say this, just because you're making the same after an injury, by the way, this is almost always physical injury, which we don't have here. But just because you're making the same or more doesn't mean you're foreclosed, but you have to prove that there is some nexus between what happened and your inability to earn. And in response to a question, Dr. Chaudhry argued to you that there was expert evidence. Judge Edwards made the very good point. It still has to rest on facts. But I do want to note that there was a single point mentioned in the briefs, the initial brief at page 21. And in that brief, Dr. Chaudhry said to this court, Dr. Krause offered opinions that within a reasonable degree of economic certainty, Dr. Chaudhry's termination caused him to lose wages in the past and earning capacity in the future. Actually, that is not what the record says. At transcript 1280, Dr. Krause was asked the following: based on your years of training and your review of the record, do you believe that because of his termination from Florida Hospital, Dr. Chaudhry has lost income in the past, as well as the ability to earn a certain amount of income in the future? Answer: yes, I do. And then they changed subjects. There is no evidence from Dr. Krause that this doctor suffered any kind of capacity that would permanently or otherwise limit his ability to earn an income. What the record establishes, and that's the only record site they give you, what the record establishes is, as I believe it was Judge Edwards noted, it may have been Judge Wallace, the very fact that the first recruiter he talked to, and others as well, said, I can't get you a job without board certification. Florida Hospital gave him a chance because he had only flunked once and he had 2 more shots. But by the time he had flunked the 3rd time, he was no longer qualified to take the exam again. And so
Didn't the jury have all this information in terms of what's available, in terms of pay? And since we're not trying to establish the wages of a truck driver or somewhere where there's thousands of instances. We have a rather limited area here of data, and they heard all of it, what a transplant surgeon gets, what the chief gets, this, that, and the other, and the jury heard all that and sorted it out. Why should that have been taken from the jury?
Because there has to be a threshold gatekeeping function to determine whether the plaintiff can where the plaintiff is making the same or more, the question arises, can you possibly prove reduction in harm to capacity? And that is a legal issue that must be determined by the court. Otherwise, it's just a wash of all sorts of data. But here you're right, Judge, the problem was exacerbated and made more harmful because there was evidence given about what a director of a heart and lung transplant or cardiovascular unit at a large teaching hospital would make. The irony here is what Dr. Chaudhry did prove below is what Dr. Bittner should be paid. A 30-year surgeon who ran a heart and lung transplant unit, who had 520 heart surgeries under his belt and had trained and taught at Harvard and Duke. That was the evidence the jury was allowed to hear without a commensurate understanding that the law doesn't allow that recovery. It's too speculative. That's a legal issue, Judge Edwards. We submit that the trial court should have used the gatekeeping function to keep under control.
All right, Ms. Downs, let's move on to your cross appeal.
Thank you. We have I would like to focus briefly in the interest of efficiency on some fundamental facts and points of law before this court that we submit, as you well know, dictate reversal and remand with instructions to enter judgment for Florida Hospital. First of all, this was a negotiated employment.
Yeah, but you're suggesting that you can contract away, your rights under and protections under a Whistleblowers Act, and I find that a very difficult argument to swallow.
Judge Cohen, respectfully, that is not what we're arguing. That is what the plaintiff responded by saying. We're not saying that at all. I agree with you. I don't think you can waive rights under a statute in the future, except perhaps under certain limited circumstances. But here's what we are saying. 448.105 says nothing in this chapter will diminish an employment contract. It's a whole separate part of 448. So we're not saying it was waived. We're not saying he contracted.
I'm going to put you on hold for 1 second. Let's stop the clock. We appear to have lost Judge Edwards. And contrary to what some people say, I think it really is a loss.
We'll let him know you said that when he comes.
Oh, you can let him know. Yeah, you can let him know.
Not just a theoretical or speculative loss, but a certain one.
All right, let's see what we can do.
Did the Supreme Court come to get him?
Maybe.
Oh yeah, I don't know.
Marshall Crawford, are you trying to reach out to Judge Edwards?
Yes, sir. IT's in contact with him. He's trying to get back on now.
All right.
Judge Cohen. He's going to be joining by phone. He's having internet problems apparently.
Okay. Just let us know when he's on.
Yes, sir.
This really isn't his fault. In anticipation of some pay cuts, Judge Edwards has been trying to reduce his expenses, and he started with the cable bill.
It's so stressful, the technological stuff.
Yeah.
It doesn't work.
You just have to, go with the flow a little bit.
I think he's on now, Judge.
All right, Jim, Judge Edwards, do we have you?
Can you hear me now?
Yeah, we can
Can you
hear you now. Yeah,
okay.
we can hear you.
Sorry about that, everybody.
Next month, pay that cable bill, will you?
Yeah, you never can tell who's out doing gardening around, right?
Yeah, I know. All right. Okay. So, Ms. Downs, Mr. Connolly, because we've had this interruption, I'm going to give you all, it takes a little bit to get back into the flow. So I'm going to give you all a little extra time. I'll make sure that, it's equal in terms of the extra time that we allow. So the extra minute or two. All right, Ms. Downs, you may
Thank
continue.
you. And I failed to reserve 5 minutes for rebuttal on my, if I could do that. So back to focusing on, and I just want to say again, I completely agree, Judge Cohen, this is not an argument that there's some kind of waiver. This is simply that the statute does say two things that have to be read in conjunction with the entire statute. One is 105 says employment contracts aren't diminished. So query, of course, how termination pursuant to a contractual provision could qualify as the retaliatory harm that's protected here. But we don't have to go that far. But we also have to remember that 103 is important because 448-103 says, hey, this statute only protects what it protects. It doesn't go farther than that. And we know as a matter of law that a statutorily created cause of action such as this one is only what it was created to be. So the importance of that feeds right into this court's decision in Griffin, which 2 of our judges here today were a part, of course, of that Griffin bench that issued that opinion. And because there were numerous non-protected reasons given for the termination of Dr. Chaudhry. One, the low surgical volume.
Yeah, and I understand all that, but I'll tell you that first of all, I think a lot of this seems to me to be a question of fact, but there are all these issues between the Chaudhry and the and the head of the program, and so Chaudhry says, listen, if you all don't peer review this leaving of a implement during the course of the surgery and other issues that he had, that I'm going to go when UNOS gets here, I'm going to raise these issues. And you've got emails then that say he's going to cause problems with our certification on the site visit, and they fire him and remove and get rid of his access so that he can't be part of that process. I mean, why isn't that sufficient to make this a question for the jury?
Several reasons. First of all, keep in mind that there was one memo, and it was on February 18th, early in the morning of the UNOS visit. He was terminated on the 4th within 3 or 4 days of flunking or receiving notification of flunking his boards. Most important, perhaps, though, is the fact that the Florida Whistleblower Act only protects protected activity.
Well, going back to the boards, there was also some evidence that that wasn't the reason for his termination.
Your Honor, there were multiple reasons given that have nothing to do, that are legitimate business reasons. He flunked his boards. He didn't develop a referral network. He failed to get the respect of other physicians. The whole team wasn't coalescing. The low surgical.
But every one of those things is contrasted in the evidence by prior reviews of his performance. It just strikes me, Ms. Downs, that there's enough evidence there to have gotten this to a jury. That's a jury question.
Here's the problem, Your Honor. The UNOS visit, there are no rules as required by the whistleblower statute under UNOS. It is a voluntary participation. The first major ruling in this case was that UNOS could not support a Florida whistleblower claim because the statute itself says there has to be a report of a violation of a rule or law. Congress never passed any rules. UNOS is voluntary. And so Florida Hospital.
Once Florida Hospital decides that they're going to go and attempt to get that certification, it seems to me that that's relevant.
But Your Honor, it doesn't comport with the statute's requirement that it be a violation of law. But even on your point, Judge Cohen, the Griffin case, which keyed off of the Ruskowitz case, says that once a legitimate business reason is given, and at the very least, flunking the boards and no longer being qualified to even take the exam again is a legitimate business reason where the record is undisputed. They had to have a board certified surgeon. He had to show to this court that reason, those business reasons, were so inconsistent, so weak, so implausible, so incoherent, and so so contradictory that the employer's reasons simply couldn't be believed. And we submit under Griffin the idea that 2 weeks after he was fired, the single memorandum said, let's don't have him on site. He was fired on the 4th, the UNOS visit was on the 18th, and the UNOS certification had nothing to do with what's required by the Whistleblower Act.
I don't know how many memorandum you need, but let's go and talk about the jury instruction.
Yes, sir. And so that's another point. As this court knows, the McDonnell Douglas burden shifting test, which came into play as a result of that case, requires and narrowed the causation component that a plaintiff is required to show. Substantially prior to that, as this court knows, a motivating factor was a significant enough charge. In other words, the jury was told, if you find the whistleblowing activity, which we don't have here, is a motivating factor, that's enough. And the Nassar decision said, no, it has to be but for. It has to be a strong causal relationship between the protected activity, that is the reports of violation of law, and the activity. So keep in mind, Your Honors, that there was a 6-month delay between Dr. Charter starting to complain about Bittner in August of 13 and February of 2014 when he was fired, another resubmit problem. So what happened, as this court knows, is that the law of Florida is you don't give a jury instruction if the case law is contrary. And of course, jury instructions don't always keep up with changes in the law. In fact, there's a great quote from this court, Judge Cobb, who pointed out in Harvey v. State that sometimes Trial attorneys and trial judges fail to recognize that jury instructions promulgated by the Supreme Court or affinity were not immutable postulates from Olympus. Here, the trial court issued or identified her concern that Nassar was the law of the land and applied in Florida. It's been applied to retaliatory claims. It's been applied to the Whistleblower Act, albeit the public component. And so the problem here is the jury was instructed on an out-of-date instruction about the law that the state of Florida does not follow. All retaliatory cases now follow Nassar with one exception, and that is Judge Kavakovich's opinion in the Norman case, in which in a footnote, she disposed of Nassar. To be fair to Judge Kavakovich, she was dealing with a 2012 case. And when she issued that opinion, the Nassar decision had just come out. And that is the single case, and it's been never followed and not cited with approval. And it's a federal district court trial judge. So we respectfully submit that Nassar is the law of the land. It applies to whistleblower cases in Florida. It applies to retaliatory cases in Florida and virtually everywhere. And that should have been the jury instruction given rather than standard instruction.
All right, Ms. Downs, we'll go ahead and let you reserve, and I'll give you at least an extra minute or two. And Conlon?
May I proceed, Your Honor?
You may, and I'll give you an extra couple minutes if you need it as well.
Thank you, Your Honor. Let me just do some quick hits on the main appeal on reply, and then I'll address the cross appeal if that's acceptable.
Sure.
First of all, a couple of supplements to what I said about the record. Dr. Krause also based his opinions upon individual salary data for people below the level of directors of programs or heads of departments. On page 1366 of the trial transcript, he testified he considered salary data for other transplant surgeons at UCLA below Dr. Ardelli, who's the head of the department, and also at UCSD and UCSF, which are all public facilities, so those salary data was available. So it wasn't just at the director or department head level that he was considering. With regard to whether he'd be able to work again in the field after he was terminated, Dr. Chaudhry also testified about this, transcript page 1092, and our hospital administration expert, Jay Ziskind, also testified about it at the transcript on page 586. This is covered in page 20 of our initial brief. And I thank Mr. Weissman for tipping into one of those remotely. Ms. Downs mentioned that, or argued that loss of capacity to earn income is usually based upon some physical injury. That's not true. We cite the Erie case where I think it was based upon depression. And then also the Williams case, I think out of the Seventh Circuit, which was a Federal Civil Rights Act case where there was reputational injury, which was alleged as the basis for loss of earning capacity. That's argued in our briefs. The issue of, wasn't this just for the jury, which Judge Edwards brought up, about all this was in evidence. This testimony that they claim is speculative by Dr. Krause was not objected to. It was before the jury. It was never stricken. And a trial judge is required to consider all of the evidence when ruling upon a motion for directed verdict or JNOV as here. It was in evidence. And we cite the Singer versus Borbua case, 497 South 2nd, 279, 3rd District, 1986, for that. And so where that was here, yes, it's not perfect, but you're not going to find evidence of what other 3rd or 4th year heart and lung transplant surgeons who've just been fired end up making it the next job, and if how long they last in that and whatever.
Why would Dr. Bittner's records have been material? I mean, it's kind of like you're looking at somebody who's entry level and then looking at somebody who's a superstar.
Well, Dr. Chaudhry, though, already was relatively a superstar in terms of the rest of us. He's a heart and lung transplant surgeon who also does VADS. He survived a UCLA fellowship for 2 years. I mean, he can do this job. His evaluations were excellent before he started whistleblowing and they started getting upset. So to say that he's never going to get a raise, he's never going to get promoted, he's never going to lead a program, because that's speculation. It's just a speculative, I would submit, to say that he's going to stay in that same staff position.
Say that it was at least discoverable whether or not it was admissible?
Correct. As terms of Dr. Bittner's contract, yes. And maybe it breaks out. This is what we pay him for his surgical duties. This is what we pay him for his administrative duties as a director. And so that could be broken up even. But it was calculated to lead to the discovery of admissible evidence, and there was no privacy right alleged, et cetera, on that.
Let's talk about the jury instruction. I think that's pretty important.
Yes, Your Honor. On that, first, we've raised a preservation issue. They have
Yeah,
cited-
yeah, I can tell you that I could spend this entire oral argument talking about that issue. I find it, almost to the point of being disingenuous. I mean, they specifically had, the trial judge even found that issue had been preserved for appeal. They argued, that the but-for standard was the proper instruction to give. And the trial court indicated, no, they gave a proposed instruction that sufficiently set forth the but-for instruction, and you all fought it, all the way down the line. And the record on this, when you look at the preservation issue that you've raised, just doesn't support your position.
I'm going to take my cue from Your Honor and move on then. On
Okay.
that, I submit that.
Well, I'm only, you don't need to do that. I can tell you that I'm one vote on this. You can well convince Judge Wallace and Judge Edwards that you're right.
Let's get to the merits.
All right, or maybe you can't.
I'll rest on the brief on the issue, but
Okay.
I do submit that we did at a good faith basis under the law that we cited, but I'll move on from that. The issue here is, does Nassar's adoption of the but-for standard of causation in federal Civil Rights Act cases automatically apply here in Florida Whistleblower Act cases? There's no automatic legal reason why it would. The Florida Whistleblower Act statute does not borrow federal law like the Florida Deceptive and Unfair Trade Practices statute that we cite in the brief does. So it's just, by logical analogy, courts have applied the federal civil rights framework, both the McDonnell-Douglas issue for burden shifting and summary judgment, et cetera, framework, and then now this causation standard as kind of, somebody else has evaluated a similar thing, and so we're going to go with that. But here, the statute is different on causation. And I've cited this and argued it, and Your Honors have that to see, but it's in 448-103, where it provides that an employee, this is sub C, an employee may not recover in any action brought pursuant to the subsection, skipping ahead, if the retaliatory personnel action, his firing, was predicated upon a ground other than the employee's exercise of a right protected by the act. And so that language indicates that if the retaliatory personnel action, Dr. Chaudhry's firing, was predicated upon his firing and some other ground, he wins. If it's only predicated upon some other ground, he loses. So this language in this statute was used by the jury instruction committee in formulating its motivating factor instruction. And it's cited as a basis for it in the notes on use below the jury instruction.
Mr. Connolly, if you assume that Ms. Downs and Florida Hospital is right as far as the jury instruction argument goes, why don't we also provide the remedy that Ms. Downs was alluding to, which is a retrial, but you don't get to retry the case as far as loss of future earnings?
Well, I think the issue would, setting aside the second point in the main appeal on the discovery issue of Dr. Bittner's contract, if this is to be retried on the causation in that jury instruction, I think it would be either, the entire case is retried or just the causation issue would be retried, which may require liability. I'd really want to put more thought into that, actually. But it wouldn't just be loss of earning capacity. But if the court is going to rule the evidence wasn't sufficient on loss of earning capacity, but they were entitled to Dr. Bittner's contract and discovery, so they should get that and a new trial on loss of earning capacity, then I think both of those would be teed up in any new trial if the court reverses on this jury instruction issue.
So is Dr. Bittner's personnel file and the records and the proof of his earning capacity, Dr. Bittner's, and how that reflects upon your client's ability to earn money in the future, is that really the only evidence that's missing from a retry of this case? Obviously, your client still remains employed in the state of Kentucky at a higher pay salary than he had down here in Florida. So what other evidence is there out there other than Bittner's file that would prove relevant in a retrial on this case?
Well, Your Honor, I cannot say that I know what his employment situation is right now. At the time of trial, he was employed at Kentucky 1 for that salary. I don't know what his employment status is right now, if he has a job or not. And so that may be open if there's a retrial on this issue as to what his set-off would be on an earning capacity claim. And then I don't know what Dr. Bittner's contract and salary is shown there would reveal in terms of whether or not there would need to be some other discovery or some other evidence introduced. So I wouldn't want to foreclose our ability to reasonably seek such additional information and introduce such evidence.
Did you seek just as information on his salary or his entire personnel file?
I believe it was his contract, including his salary information. We may have sought his personnel file, but I think we moved for reconsideration on his contract and his salary information.
Okay.
But I've cited to that in the procedural history of the initial brief. That's exactly what was sought and the record cites for it.
Let me have you address one more thing here. How should we consider adopting either the airy, kind of the good faith belief that Dr. Chaudhry believed there were violations of law, versus Kearns, which seems to suggest that Chaudhry would actually have to prove that there were violations of law in order to be entitled to pursue a whistleblower act?
Yes, Judge Edwards. That's actually not an issue on this appeal that I'm aware of. The trial court ruled pre-trial that we were required to prove actual violations of law, and we traveled that way in the case. And so we weren't attempting to get into evidence things that he only had a good faith belief in that weren't.
We have enough issues to deal with without creating new ones.
I'm not sure. Does the court think so or not in this case? But we put forward evidence of violations of law, and the jury found that there were violations of law. And so, for purpose of this appeal, we submit that resolves it. And Your Honor, am I into my extra time or?
Yeah, no, you're 2.5 minutes into it.
Okay.
I've allowed you to go beyond the expired time.
Okay.
So why don't you go ahead and wrap up, and I'll give Ms. Downs an extra 3 minutes as well.
Okay. Well, I'll just thank the court for its hard work and attention here. Obviously, Your Honors have really given into this. I'd ask the court for the relief of finding that the court has invaded the jury's province, and the court should reinstate the verdict for loss of earning capacity, because there was evidence in the record that was required to be taken in the light most favorable to Dr. Chaudhry on this issue, and reinstate the verdict in full. If not, reverse for production of Dr. Bittner's contract and salary information, and a new trial on loss of earning capacity. And we'd ask that the court affirm on all issues on the cross appeal. Thank you, Your Honors.
All right, thank you, sir. All right, Ms. Downs. You have to unmute, or it makes it very difficult.
Thank you. Thank you. I was just saying briefly, as lawyers always do at a time like this, and then they're not brief, but just to hit a few high points. We strongly argue, as you know from the briefs, that there was no proof of a violation of law, which again, we believe the Whistleblower Act that we don't just believe it. The Whistleblower Act requires it. It's interesting that the Erie decision came up, and as I'm sure this court knows, the 4th DCA just recently took a shot at Erie by saying we are being urged to retreat from Erie. We're not going to do it here today. That was in the Cole case. This was May 27th, 2020. And I want to note that neither Wright, which is the 4th DCA, nor Griffin were even addressed in the papers below by Dr. Chaudhry. The problem with Erie is, and it appears that the 4th may well retreat, is that's not what the statute says. And because this is a statutorily created cause of action, we have to be very limited in what we allow a plaintiff to travel under. But I also want to mention Erie and Kearns for another reason, and that is that under Kearns and Erie, and this is why the bad jury instruction not following Nassar was so important, it's a narrowing of the causation standard. And so, but for the complaints is the way the Nassar cause instruction reads. And here, under both Kearns and Erie, if we fire Dr. Chaudhry because of UNOS, about which there is no rule, and whether the hospital wanted voluntary certification or not is outside the protections of the Florida Whistleblower Act. We have a
the UNOS allegation was just one part of it. It wasn't, the end all.
Well, the problem with the UNOS visit 2 weeks after he got notice he flunked his boards again is that's the only thing they can tie, because they've got a problem, because he started complaining about Dr. Bittner being a bad surgeon in August of 2013. He wasn't terminated until February. As a matter of law, under the federal cases, 6 months is too long to establish.
He didn't exactly, he didn't quit complaining about Dr. Bittner or some of the practices. It's not like he made one complaint and stopped and 6 months later picked up.
Correct. All the more reason why the two were unconnected. In fact, if this record proves anything, it's that the parties all tried hard to solve these problems, and then Florida Hospital, although it could have terminated for cause, said, we're going to exit pursuant to our contract and employment agreement without cause. Dr. Chaudhry kept the money. But I want to go back to the violations of law, because I do want to say briefly, at 395, remember after the DV was argued, the trial court judge finally made the plaintiff lock down and say what violations of law they're going to go to the jury with after years of litigation. And they picked 5 things. 456 applies only to the department by its own express terms. 458 is a licensing minimum standard chapter. 395 requires a risk management program, which we had undisputed in this record. Chapter 395, the other subsection, requires a peer review process. But here's the problem. What Chaudhry wanted was a peer review process within a time period that's not in the statute. And he wanted an outcome he never got. Neither of those things are violation of law. And we submit that under Kearns and Erie, if you properly instructed the jury, we can say we want him out of the hospital when UNOS comes to visit, because he had already been fired 2 weeks before. And again, as you know, we believe strongly that under Griffin, this cases dictates in Griffin, how can you say him flunking his boards was so...
That's probably the 6th, 7th, or 8th time that you have raised that phrase, and yet there was evidence in this record that the failure of the boards was not the reason for his termination. So I don't know why you keep emphasizing that with us when the jury could have decided to accept the evidence that that wasn't the reason that Florida Hospital fired him.
Well, but Your Honor, Florida Hospital testified by 4 different witnesses that he was fired for all of those reasons: the boards, the laziness, the surgical volume, the referral problem.
There's evidence on every one of those that on his reviews and emails that conflicts with that, and so it just strikes me that that's a jury issue.
Well, I understand. Obviously, you're the Griffin Court, but when you look at the kind of language that is required under this court's rules or this court's Griffin case, it's that it's a sham. Who can say him flunking the boards and no longer being qualified is a sham? In fact, one of the phrases used by Ruskowitz is that it's made up, that the excuse to fire him is made up, it's concocted, it's a pretext. No, it was an undisputed fact, and it was one of the reasons these parties bargained hard for a way to walk away from each other, which they did. And how that, yes.
All right, you can do it. Go ahead and conclude.
Thank you, Your Honor.
All right. Thank you. Now, thank you both. I want to say that this was well briefed and was well argued. And Mr. Conley, while I probably was a little strong in my statements in terms of the preservation issue, I don't want that to take away from the fact that I think that y'all have presented a very interesting case, and B, it was exceptionally well briefed and well argued. And I can speak on behalf of the other members of the court that we appreciate the work that y'all have done on this case.
Thank you, Your Honor.
All right, thank you.
Thank you.